counsel. Justice Thomas, anything further? Justice Alito?
Oh, you say that the Fifth Circuit didn't give any reason to think that the 3 changes made in 2016 would be more dangerous in combination than they were individually. But isn't that obvious that 3 things that may be innocuous or not excessively dangerous, if engaged in by themselves, may become very dangerous when they're all done together? And why shouldn't the FDA have addressed that?
I think the only way that that would be true would be if the 3 changes are interconnected and mutually reinforcing, guarding against the same kind of safety risk. So I agree that if there were a reason to think that the reason why Mifepristone is safe up to 10 weeks gestation is because it's being prescribed by doctors instead of nurse practitioners, for example, then those changes would be interconnected because one change would effectively be the safety net for another. But there was nothing like that in this record. The studies that FDA examined instead demonstrated that these changes, and it was an exhaustive examination, were safe not because there were other different safeguards in place to guard against risks, but rather because if you go up to 10 weeks of gestation, there is no observable increase in serious adverse events, no matter who's prescribing. So in the absence of that kind of correlative effect of the changes, I don't think you can fault the agency for not giving even more explicit attention to this issue. And it did. It cited multiple studies that combined multiple changes precisely because the standard of care had evolved over the 15 years Mifepristone had been approved, and many of the changes were already being deployed together safely.
Shouldn't the FDA have at least considered the application of 18 U.S.C. 1461?
So I think that the Comstock provisions don't fall within FDA's lane. FDA, under the FDCA, can only maintain restrictions under the REMS program if it's necessary to ensure safe use. In 2021, what FDA determined is you don't need in-person dispensing for safe use, so the FDCA did not independently require that REMS restriction, and in fact, it couldn't be imposed once FDA had made that determination. Now, that doesn't affect other sources of law. FDA was not affirmatively approving mailing in violation of Comstock, even if you interpreted it that way, and we don't think it means what respondents suggest it means. But at the very least, I don't think that it was FDA's responsibility to consider that, nor could it have permissibly considered that under the statute.
Well, it didn't say any of that. It didn't say anything about it. And this is a prominent provision. It's not some obscure subsection of a complicated, obscure law. They knew about it. Everybody in this field knew about it. Shouldn't they have at least addressed it? You have answers to the arguments that are made on the other side. Shouldn't the FDA have at least said we've considered those and provide some kind of an explanation?
Well, let me give 2 responses. One is that I don't think it would have even been permissible for FDA to consider maintaining this restriction because of Comstock. If you look at the relevant statutory section here, it's 355-1G4. This is reproduced at page 6A of the appendix to our brief. It's very clear that the only thing FDA can take into account for restrictions are safety and efficacy concerns in deciding whether to maintain a REMS program. But the other thing I would say, Justice Alito, is that the agency did have a memorandum on Comstock. It's at JA 535. That was the advice that FDA received from OLC conveying the interpretation of Comstock.
They got the advice from OLC, but it didn't refer to that, did it?
In the 2021 decision, no, but the REMS was then modified in 2023, and this was part of the administrative record for that.
Okay, one last question. The plaintiffs say that the studies that the FDA relied on for the 2021 amendment say that mail order Mifepristone suggests more frequent trips to the emergency room. Now, this is what I see as the FDA's response to that. Quote, although the literature suggests there may be more frequent emergency room care visits related to the use of Mifepristone when dispensed by mail from the clinic, there are no apparent increases in other serious adverse events related to Mifepristone use. Does that really count as a reasoned explanation to the suggestion that the data shows there are going to be more emergency room visits? This is the increase in emergency room visits is just of no consequence. It doesn't even merit some comment.
That is a reasoned explanation. What FDA was observing in that passage is that although it acknowledged the fact that some of the studies reported additional emergency room visits, that didn't equate to additional serious adverse events. And in fact, one of the studies, half of the women who went to the emergency room didn't get any treatment at all. Many women might go because they're experiencing heavy bleeding, which mimics a miscarriage, and they might just need to know whether or not they're having a complication. But in that kind of circumstance, the woman is not having a serious adverse event from mifepristone, and so it doesn't call into question the safety determinations regarding the drug. And at the end of the day, FDA carefully parsed those studies. It made specific determinations about the results to be gleaned with respect to safety and efficacy. It fully explained its decision-making, and I think it falls well within the zone of reasonableness under arbitrary and capricious review.
All right, thank you.